Hello, everyone. Welcome to John Redmann, Power of Attorney, the show that aims to empower you through your knowledge of the law. I'm Attorney John Redmann.
And hello, everyone. I'm Shauna Sanford. Welcome to the show. If you've been following the fallout from the BP oil spill settlements, then you are well aware of the serious allegations that have been raised by both BP and critics of the oil giant. BP alleges that some individuals and businesses have made false claims and been paid improperly. The company is currently appealing the settlement it agreed to, claiming it's not being properly enforced. BP has even criticized the judge and the claims administrator who's responsible for paying the claims. Now, on the other side, advocates of the settlement say BP has crossed a number of ethical and decency lines. In this case, BP's spending of a reportedly nearly $1 billion on a PR campaign to cast BP as the good guys and victims of the massive oil spill and their lawyers as the bad guys raises yet more ethical questions.
We have two guests today who will take a closer look at the issues on both sides. Local attorney and ethics law professor Dane Cialino and attorney Russ Herman will join us right after this break, so stay with us.
We can beat this. The spill in the Gulf is a catastrophe.
But we will solve it.
This is not a Gulf Coast issue.
This is a national problem that requires a national solution.
But what can you do to help?
What do you have to offer? Your voice.
Speak up.
Add your name to the petition
Demanding restoration and protection
Of America's Gulf Coast.
Sign it.
Share it.
Be the one.
Be the one. RestoreTheGulf.com.
Hello, everyone. Welcome back to the show. Last week, we had a great discussion with attorney Patrick Juneau, the man in charge of evaluating and paying BP settlement claims. Today, we are continuing the conversation about whether any ethical lines are being crossed in the latest fallout from the case.
Joining us on the set today are two highly respected attorneys in New Orleans. We welcome back Russ Herman to the show. Russ is the senior partner of Herman & Katz, a graduate of Tulane Law School. He also successfully led the team that found the tobacco industry intentionally addicted, misled, and defrauded Louisiana consumers. We also have attorney Professor Dane Cialino with us. He graduated from Tulane Law School. He has written a new book called Louisiana Legal Ethics and is currently teaching law at Loyola University. Gentlemen, thank you for joining us today. We look forward to this discussion.
Yeah, it is a great pleasure to have you here. And before we get into the discussion, you all know this, but we need our viewers to know that we did invite BP to be a part of this discussion today, and they declined to be on the program. However, Jeff Morrell, the spokesman for BP, did send in a statement, and that statement reads, BP stepped up in the wake of the Deepwater Horizon accident and continues to do so, having already paid more than $26 billion on response, cleanup, and claims. Today, we are working to ensure that our willingness to do the right thing is not taken advantage of and distorted to provide windfalls to undeserving businesses, including law firms. While we remain committed to paying legitimate claims, we did not agree to pay for fictitious losses or for claims that are based on fraud or tainted by corruption. We are defending our rights, shining a light on abuses, and keeping people informed. We owe it to our shareholders and employees to do so, and we believe everyone should know that the unmooring of this settlement from the express terms of the agreement changes the calculus other businesses will consider when deciding whether to settle or litigate. End quote. So that is the statement from BP, and I'm pretty sure that you all have some responses to that. And I'm going to start with you.
I think it's an interesting statement from a serial killer that's been convicted of lying under oath and has the worst record in its industry. 97% of all safety violations, according to OSHA, were committed by BP before this latest catastrophe. And of course, they've got a multi-million dollar mouthpiece named Morrell. Nobody can challenge him. He's not a lawyer, but he's in charge of a PR campaign that's approaching $1 billion, and the motives are wrong, and the violations are serious and ethical.
And we should make it very clear that your firm is representing some of the claimants.
We are very proud that we are representing shrimpers, oystermen, businessmen and second responders, and also that Steve Herman, I want to say, with Jim Roy of Lafayette, is co-lead counsel for Claimants. That doesn't change the fact that BP now twice has caused death, disaster, pollution in the Gulf in a 10-year period, and has managed to kill 12 people who they can't even remember the names at the same time. Am I angry about it? What I'm really angry about it is their breach of ethical conduct. They are unethical. They have indicated, inferred, and stated that a member of the judiciary in high esteem and that a claims administrator in high esteem have hijacked, which incidentally is a word of art that means crime, have hijacked the settlement. I resent it, and I'll speak more about it, but that's my response.
Yeah. Dane, we're talking about ethics here, and you've written a book on ethics. And tell us what it is that you find so striking when it comes to that issue concerning this case.
Well, what Mr. Herman is talking about, things being unethical kind of in the moral sense, I'm really more focused on the ethical conduct of the lawyers that are involved, because that's what I teach at Loyola is legal ethics. But this case, really, there's no shortage of legal ethics issues either. There have been allegations and investigations into some alleged misconduct of one of the junior claims administrators for having perhaps a conflict of interest. Judge Barbier has appointed a special master, actually the former head of the FBI, to look into those allegations of misconduct, and that's something that's underway. And again, at this point, they're only allegations until the investigation is complete, obviously. But one thing that Mr. Herman does mention as something that he finds great trouble with is BP's, as he described it, billion-dollar PR campaign that we've all seen because we all watch TV in the Gulf region, and we know that they have really been pushing hard about this settlement that, on the one hand, many have said they agreed to it. It's their settlement, and it's now time for them to live up to it. And on the other hand, BP is, through its PR mechanism, putting out there its alternative version, which is, this is not the deal we agreed to. It's not fair to hold us to that. Now, whether that's ethical or unethical is a philosophical question, and I'm not going to argue with Mr. Herman about that. But if lawyers were involved in this, and this is a matter that is at least a significant issue right now, is under advisement before 3 judges in the United States Fifth Circuit Court of Appeals that is deliberating the matter. It's been under deliberation for something on the order of 2 or 3 months now. A decision could come any day. BP is fairly obviously trying to influence this panel and what that panel is deliberating now. Lawyers shouldn't be involved in that kind of effort to influence judges through an extrajudicial process. Now, I don't think there's any evidence, Russ, that any lawyers were involved in orchestrating that campaign, but it's happening, and whether it's a legal ethics problem, probably not. Whether it's a larger ethics problem is really subject that's validly.
And for people, and before you jump in, because I want you to, but for people who may not be aware, they have taken out huge ads in major newspapers all across the country, 3 major newspapers, saying exactly what you just said. Really trying to, they are talking about fraudulent claims that have been filed, that people are misleading, giving false and misleading information. And I know that you want to jump in there, but we want to make that clear what we're talking about.
Well,
when we talk about the PR campaign.
BP has said that there are 5 or 6 claims that they've used as examples out of 200,000. They said maybe some lawyers did something wrong, a handful, out of more than 1,500, 1,600 lawyers who haven't filed claims for their own law firms but represent legitimate businesses and claimants. What I'm concerned about is you owed candor to the court. That's number 1. Number 2, you have to be fair to the opposition. So what they've done, that's principles lawyers have to follow. What they've done is they've got a multi-million-dollar mouthpiece. He's like a jukebox. You put the money in, and he'll play any tune. That's what Mr. Morell is. So he's not bound by legal ethics. So they're doing, through him, what their lawyers haven't done, couldn't do, and I'm not implying that they did.
But when you say candor to the court, what do you mean? How is it that they have not given candor to the court?
Well, when you say that a court has hijacked a settlement, not only that you agreed to, but you stood up in open court and said, Judge, please approve this, to me, you are not being candid. You're not being candid in the appeal that you filed or the argument you made. But more than that, there's a violation of what we really, either we lawyers have higher ethics that BP doesn't have to subscribe to, or they are bound by our ethics. It's got to be one or the other. My objection is, if we look at Judge Barbier, born in New Orleans, played 3 sports in high school, scholarship to Southeastern, graduates with honors from Southeastern, goes to Loyola Law School at night while he has 2 jobs. He clerked on the 4th Circuit Court of Appeal for the state and the district court and federal court. He was law review. He's been on the bench for 15 years. To say that he is not impartial or somehow incompetent, I think is outrageous. Then if we look at the special master or who is the claim, and incidentally, one more thing, Judge Barbier was chosen for this job by 7 federal judges from 7 different states among all the judges that could have handled this. Now, if we look at the claims administrator, Pat Juneau, he's a past president of Louisiana Association of Defense Counsel. He also got a unanimous vote to be a diplomat at the International Academy of Trial Lawyers. There are only 250 defense lawyers in the world in that organization. He is selected by 5 different cases by 4 different judges in 4 different states to administer as a special master these cases. It's outrageous to say, number one, his interpretation is wrong, particularly when he his office advised BP well in advance, before their lawyers stood up in court and said, Judge, please agree to this settlement. Advise them in advance that that's the way it was going to operate. And I just think, if I don't do anything else on this show, the attack on the judge, the attack on the administrator, outraged me as a lawyer. I've been at this 47 years. And we know when we lose, it's because we either don't have the facts or the law. We may disagree with the opinion, but we don't attack the judge.
And is this where we see the ethical problem here?
Well, there are rules of ethics that prohibit lawyers from making obviously false, but also reckless statements about the qualifications of a judge. Now, here, as Mr. Herman has stated, it's not so much the lawyers that are making these statements as it is BP and its spokespeople. Now, and as also
that's an important distinction to make.
Well, it is from the standpoint of legal ethics and the authority of the court over over the lawyers for BP. They are not the ones who are making the public statements. Their client is, and as you know, Mr. Herman and we all understand as lawyers, is that we are not responsible for all the things that our clients do. Now, one of the problems that the plaintiffs' lawyers have is they are bound by these rules of ethics, and they are sharply limited in what they can say and do by way of making extrajudicial statements, that is, statements outside of the courtroom in the court papers about the case. By and large, lawyers are supposed to speak their minds and advocate their clients' cases on the record, in court filings, not in the Wall Street Journal or the New York Times or on TV. And because of those limitations on the plaintiff's lawyers, it's really been almost a one-sided PR campaign because the plaintiff's lawyers really don't have an opportunity to respond. Now, I'm not taking a position one way or the other on whether what BP's saying is true or false. All I'm pointing out is that BP is the only party speaking publicly about these issues with this PR campaign because the plaintiff's lawyers really can't.
We got to take a break. I'm going to let you get that thought in as soon as we come back on the other side. And when we come back, we will take your questions for our guests as well. Stay with us. We'll be right back.
I am for the child who lives in motels, cars, and shelters, now in foster care, a group home, where he sleeps not on a bed, but on a temporary cot. He is the child I am for. I am a CASA volunteer. I am you.
And welcome back to the show. Our guests today are attorneys Dane Cialino and Russ Herman, and we are talking about the controversy over the BP settlement and allegations by the oil giant that too many false claims are being filed and awarded. And this is something that you all definitely want to get in, and we're going to get in on, and we're going to go to your questions in just a few moments. But Attorney Herman, I know that you wanted to pick up
I think
on that
it's
last
important to say why they have $1 billion campaign. Of course, at the end, they want to pay less money. But judges are human beings, and there are cases under consideration by the Fifth Circuit Court of Appeals. Do they read media? I suspect that they do. Number two, it's bait. Every trial lawyer knows that BP is putting bait out there, hoping that a very fine judge and a very fine claims administrator are going to say something in reaction, and they can't do it, shouldn't do it, and haven't done it. The third reason is to change the entire focus. We call it reframing the issue. I'm a bad guy, BP. I've killed 11 people in this latest explosion. I've destroyed fisheries in the Gulf South. I still have tar out there. I got to do something to shift from me as a perjurer and a killer to somebody else. So I'll attack the judge, I'll attack lawyers, I'll attack the claims administrator, I attack the process, and I'll spend $1 billion making me look like the good guy and changing the focus of everybody to these other folks. And that's what it's been all about.
Okay, let's get to our questions. We got a question from Mitch. Mitch says, can BP take the appeal to a higher court if the Fifth Circuit doesn't grant it? And some have said, by bringing on the attorney that they've brought on, Ted Olson, that they're really sending a signal out there that we're willing to go all the way with this.
Well, of course they're willing to go all the way. They've spent millions and tens of millions, if not hundreds of millions of dollars defending the case. And can they seek review of whatever the Fifth Circuit does by the entire court and by the U.S. Supreme Court? Of course they can, and I would expect that they will do that. They have fought this particular battle on what the scope of business economic losses should be, tooth and nail. Repeatedly, after they've lost, they've come up with different ways to make the same arguments in different filings. Very, very persistent. I would be shocked if they did not seek Supreme Court review of an unfavorable filing.
Have either one of you ever seen a PR campaign of this nature, especially with the tobacco case that you pursued? I mean, is this a first? And Dane, your take on this? Have you sort of ever seen a company go at it in this way?
Well, I haven't been around as long as Mr. Herman has been, but I have never seen, and in my years of following the legal profession and in following litigation and law, have I ever seen a campaign like this outside of the court system to try to get the court system to go in the direction that they want to go in. That's that kind of almost a lobbying effort that you see when you direct something toward the legislative branch or toward the executive branch. pleas to the judicial branch aren't made in newspapers and through letter writing campaigns. They should be made in legal arguments, in pleadings, and in court.
More than 50 years ago, the 5 big tobacco companies hired a PR firm to plan a 50-year effort. But I've never seen anything like this. Even in tobacco, the companies themselves, when they got an adverse decision, which wasn't very often, I mean, they won every case for 50 years, but even when they lost, they never, ever attacked the judiciary or the rule of law. And I've never seen $1 billion spent or approaching $1 billion in, what is this, 2.5 years? I mean, that to me is extraordinary. Why not just pay the claims and move on?
Let me let's just take 2 minutes, take a step back. A lot of people say this is buyer's remorse. BP agreed to the settlement in order to avoid punitive damages, a lot of people say. Is that what you say?
Well, that's what I say. I mean, on the one hand, the 200,000 claimants now pending sign releases of their punitive damage claims against BP. Those claims would have amounted, in most folks' judgment, far in excess of what they're paying out in claims. On the other side, it gave some certainty. People with businesses, others that had suffered, got payments that were reasonable, decided in a judicial context under supervision of a federal judge. And so one side, the claimants and the businesses give up punitive damages, and BP has to pay claims, and even though there's no causation, and the causation issue is a red herring. Yesterday or the day before in the NFL suit, $750 million are being paid to football players without proof of causation of an injury. So this is done all the time. One side gives up something, the other side gains something, then that side gives up something. It was a fair arm's length deal, and it's not just buyer's remorse. It's handshake in writing destroyed.
So BP limits how much it might have to pay, but in return, they don't get to quibble about was it really caused by the oil
Correct.
spill.
Well, and we just want to make our viewers aware who may be just tuning in that we did invite BP to be a part of this discussion today. They did decline. However, they did send in a statement. We read that statement earlier, and you can see it in its entirety on the website. We got a question here from Thomas, who says, exactly what part of the agreement does BP claim is ambiguous or too general? And sort of help us to understand that this settlement is a settlement. These are terms that BP did agree to.
Well, in open court, BP's lawyer said on questioning from one of the judges, the judge said, well, is it ambiguous? He said, no, there's no ambiguity here. So I don't understand what they're saying. What they're saying is, well, we think 3 times, we think that the administrator interpreted the plain language that we all understood incorrectly. And to me, that's not candid to the court, because before the settlement was inked, BP's lawyers and BP stood up. They knew how the document was going to be interpreted, and they asked the judge to approve it as written. So, I could tell I learned from my dad, and I'm going to tell you, 47 years ago, a lot of lawyers in this town could do business on a handshake. We made an agreement, and then we inked it. Okay? Things have changed, and this case has changed that dramatically. You can put it in writing, you can agree to it, you can come before a federal judge, and then you can disavow it later.
Well, and I think that's what is so probably difficult for people to sort of wrap their minds around. You know, it was written in black and white. They did agree to it, and now they're saying, no, we don't want the settlement as it is.
Right, and again, that's where the differences of opinion and rhetoric come from both the plaintiffs' camp and from the BP camp. BP is, again, mounting not just a local or regional or national, but an international campaign to convince people that these claims are bogus claims, is the kind of rubric, the rhetoric that they're using. And but at the end of the day, particularly when it comes to the business economic losses, that is, these are the claims suffered by businesses in the Gulf South for lost income, or at least changes in income after the oil spill. That's going to be decided by 3 judges on the U.S. Fifth Circuit, not by the Court of Public Opinion. And you know, that to me, I think, is the most interesting aspect of what's going on now.
I want to say one other thing. The lawyers that represent claimants, by and large, in Louisiana, were educated at Loyola, Tulane, LSU, and Southern law schools. They were born here, raised here, and they live here. The judge was educated, born, raised in Louisiana, went to law school here. The claims administrator, born, raised, went to law school in Louisiana. For this mouthpiece, this multi-million-dollar mouthpiece, to talk about good old boys and news reporters to say, well, I'm from New York, what do I know, is just another issue of Northeastern snobbery, and it's outrageous.
And we're going to have to let that be the last word. Thank you, gentlemen, both of you, for your time and for being on the show. Learned a lot. It's always great to have you on.
Thank you.
Thank you.
That is all the time that we have this week on Power of Attorney. Thank you so much for joining us. Be sure to join us next week when we will take on another hot legal topic. And as always, we want to include your questions.
And you can send those questions to us via Facebook, email, and Twitter. Also visit our website at johnredmanpoa.com for more information and links to everything on today's show and past episodes. Thanks for watching. We'll see you next time.